Good morning, everyone. I'd like to welcome you to our second webinar, Strengthening Governance System in Support of Forestry Carbon Markets in Latin America and the Caribbean. My name is Felipe Castro, and I'm part of LACA with FAO, and I will moderate this second block that is focused on regional experiences focused on ITMOs, authorization and transfer mechanisms under Article 6 of the Paris Agreement. I'm very happy to see you all here, and we want to thank all government representatives, GEOs, government organization, indigenous peoples, civil society, and the academia. Also, the private sector who is with us, who has joined us for this session. Before we start, some practical indications. As you can see, you can send your questions and comments throughout our sessions through the Q&A option that you have available. You can write them either in English or Spanish. You can also use them for comments and instructions. And we'd like to invite you to participate actively. And some point in this session, we'll have a space for dialogue. This webinar is held both in Spanish and English. We have simultaneous interpretation available. We have simultaneous interpretation, both English and Spanish, and you can select the language of your preference. Here, as an example, is a brief explanation on how to activate interpretation. First, you go to the 3 points that you have at the bottom of your screen, and you select the language of your preference. You can also choose to listen to the original audio. So to provide context, today we will be speaking about the different mechanisms to implement carbon markets under the Article 6 of the Paris Agreement, talking about ITMOs, their English acronym, which are the International Transfer of Mitigation Outcomes. This presentation is part of a broader series that we are holding between June and September this year, aimed at strengthening the governance system to support forestry carbon markets in Latin America and the Caribbean. I will be sharing the link to this cycle, and here you can review the presentations from prior sessions. We will begin with a presentation of Placa, UN Red, and then we will listen to two very important technical presentations, one about the relevance of Article 6 of the Paris Agreement, and another one about a toolkit for regulation reforms in the framework of carbon markets. And then we will have a panel led by Francesca Felicani. And then we will have a Q&A before we go on to conclusions shared by our colleague Roberta de Souza to synthesize today's session. Today we will be speaking about the definition of internet authorities, emissions of authorization and communications under the framework of the United Nations Framework Agreement for Climate Change, and we will also be discussing about prevention of double counting, among other topics. One of the main topics on this session is how to translate the rules of Article 6.2 into mechanisms that allow to authorize in an ITMO that is transferable. Our objective is to identify the national and institutional procedures that are needed to transfer ITMOs and to analyze how this can be done transparently and coherently with international transfers. So we will not be speaking about transaction as such, but the governance that make these processes possible. To begin this space formally, we will listen to three very brief introduction of with welcoming remarks to this activity. And to do this, I want to introduce Natalia Rumaso from the Undersecretary of Red from the Ministry of Livestock Farming and Agriculture in Ecuador. Natalia also participates with Placa, and she contributes to collaborate a work with integration and mitigation. Over to you, Natalia. Thank you for joining us. Good morning, colleagues, and thank you very much, Felipe, for providing the context of this second webinar. It is a great pleasure to participate. Welcome all. I want to cordially greet all authorities and representatives of countries of Latin America and the Caribbean, to FAO teams of UN Red and the Forestry Commission for Latin America and the Caribbean. Also to our specialist panelists and representatives of public institution, civil society, academia, and all our participants joining from different latitudes. On behalf of the Ministry of Agriculture, Livestock, Farming, and Fisheries and Placa, I would like to thank you again for inviting me to participate in this second session of the regional cycle, strengthening governance mechanisms in Latin America and the Caribbean. Today's session invites us to delve upon the transfer of ITMOs, its English acronym, under the framework of Article 6 of the Paris Agreement. This article presents a relevant opportunity for cooperation among countries, but its implementation demands much more, and we need to know the international rules. To participate responsibly in these mechanisms, countries need national regulations that are clear, authorities that are aligned with criteria to authorize, and solid systems, and an adequate articulation with NDCs at the national level. From the perspective of the agricultural sector, this discussion is particularly important. Agriculture, forests, and other land use share territories, institutions, and communities, and must also face challenges to ensure environmental integrity and avoid double counting. For Ecuador, this dialogue is also related to processes to sustain sustainability of the agricultural sector and improve capabilities of supervision. Advancing these subjects require coordination among environmental, agricultural, forestry, financial, and economic authorities, as well as an active and informed participation of productive sectors and communities. This is why we think that Placa can contribute in this process, facilitating exchanges among countries and strengthening the links between environmental, agriculture, and forestry agendas. The experiences that we will hear today, as Felipe well mentioned, together with methodological tools that will be presented, will allow us to identify progress made, gaps, and learnings that can be useful under different contexts in our region. We really hope that today's session contributes to a more practical understanding of associated practices of Article 6.2 and allows to continue building national and regional capabilities for a climate cooperation that is more transparent, aligned with the development priorities of our countries. I'd like to thank FAO again, to UN Red Program, Placa, COFLAC, to all experts, panelists, and presenters, and all participants. I wish you an excellent session and a very fruitful exchange. Thank you very much. Thank you, Natalia. Thank you again for joining our session, and particularly for providing a context of the agricultural sector and speaking about the importance of our collaboration. Next, we will invite Mr. Carlos Espinosa. He's the President and Director of Forestry at the Ministry of Environment of Panama, chair of COFLAC, and he will also be providing context from the Forestry National Agenda. Over to you, Carlos. Good morning, all. It is an honor to share this welcome note, all of you, on this webinar about regional experiences focused on ITMOs, authorization and transfer mechanisms under Article 6 of the Paris Agreement. This will be a space for dialogue, as my colleague Natalia has mentioned, and will help us exchange among government representatives, experts, and key stakeholders committed with climate action and sustainable development in our region. A context where international cooperation is fundamental to face the challenges of climate change, Article 6 of the Paris Agreement opens up new opportunities to promote collaboration mechanisms to help us work on ITMOs, as has been mentioned, and also supporting environmental integrity and providing benefits for our countries, and particularly for local community. The experience accumulated in our region in ITMOs transfer constitutes a very valuable source of learning that we must put at the service of all and that we must harness to share progress, challenges, lessons learned, and best practices will help us reinforce our international capabilities, improve governance in our territories, and also make progress onto a more effective and transparent participation in the carbon international markets. Here in Panama, for instance, we have reactivated the National Committee of Forestry Management, integrating diverse stakeholders in this committee, among them the Ministry of Trade and Industry, the and trade chambers, the guilds, the academia, the Ministry of Agricultural Development, communities, producers, and together with them, we are working and dialogue to propose new policies for the forestry sector, new laws, and so that in the next months we can work on a plan of forestry management articulating activities of mitigation of climate change, the reduction of emissions in each of the agriculture and forestry sectors, and also open up opportunities for local development. I sincerely thank all of you and your presence and the commitment of all organizations that have made this webinar possible. I am positive that the discussions that we will hold today will extend our common understanding and will contribute to the development of a solid regional agenda in terms of climate cooperation. I wish you a very productive session filled with knowledge and collaboration opportunities. Welcome, everyone. Thank you very much, dear Carlos, for conveying this message from COFLAC's chair and framing collaboration in our sectors, and also for emphasizing the work of producers and local development. To complement these regional views, I'd like to invite Mari Carmen Ruiz. She is a RED expert and works for UN RED in Latin America and the Caribbean, to listen to her introduction remarks. You have the floor, Mari Carmen. Thank you very much, Felipe. Good morning, everyone. On behalf of the UN RED program and a joint initiative of the from FAO, the UNDP, and NOMA, we'd like to extend our warmest welcome to this webinar on regional experiences focused on ITMOs, authorization and transfer mechanisms under Article 6 of Paris Agreement. This is a very relevant topic for the topics in determination of NDCs. In accordance to the world assessment FAO 2025. The region has more than 947 million hectares of forestry that represent one-fourth of the forest of the world. Forests cover approximately 49% of South American territory and 37% of Central and North America, which makes this fundamental natural heritage for adaptation and mitigation of climate change, conservation of biodiversity, and livelihoods of millions of people. Because of this strategic importance of forests, this is also reflected of climate contribution in the region. From the 33 countries that have submitted NDCs in Latin America and the Caribbean, 29 include mitigation measures in forestry or change of land use as part of their NDCs. This confirms that this constitutes one of the main sectors to achieve and to meet the Paris Agreement goals, and the need to have a robust mechanism to channel these mechanisms with climate integrity. Besides today's webinar, since last year, the UN RED program has established different technical exchanges to talk about opportunities and challenges of Article 6. In prior sessions, we've heard experiences from countries and topics on how Article 5 and 6 of Paris Agreement work, cooperation mechanisms, strategies for participation in carbon markets and ownerships, and the results of mitigation efforts, and benefits of these programs. For those of you who wish to delve upon these topics, materials and recordings are available under LACA's website. Today, we will focus on topics of mechanism and authorization of ITMOs that countries in our region have advanced, generating valuable experience that we will listen today. From UN RED, we have accompanying the countries in the strengthening of their regulation and institutional frameworks, their systems of monasteries and registry to ensure a transparent participation that is inclusive, climate integrity aligned with their national plans. We hope that this webinar is a space to share practical experiences and strengthen regional cooperation in the application of Article 6. Thank you very much for being here with us, and we hope that this is a very fruitful exchange for all of you. Thank you. Thank you very much, Mari Carmen, for presenting these figures that also help us mention the potential that forests have for the preservation of biodiversity, preservation of livelihoods, carbon capture, and for highlighting the importance of this program for climate funding. So now we'll start with the first technical block of a presentation. We will be speaking about the presentation of contextual elements and the methodological tool for the institutional normative analyzing of capacity gaps and enabling conditions. We will have Francesca Felicani Robles. She is a forestry officer in Forestry Division FAO Rome, and Gloria San Clemente, international expert for markets and climate governance, FAO Colombia. Francesca has broad experience in forestry governance in RED Plus, in carbon rights and access to climate funding. And Gloria is a lawyer, also a specialist in environmental law and broad experience in economic instruments for conservation. Francesca and Gloria, thank you so much for joining us. I'll stop sharing my screen so you can have the floor. Thank you very much, Felipe, for your kind introduction. I will ask my colleagues from communications to kindly project my presentation. Well, I'd just like to warn you that we will be presenting in two parts. First, the context slides, and then I will give the floor to my colleague, Gloria, to follow up. The objective of this presentation is to present elements of context related to Article 6.2, Particularly, we will be speaking about a methodological tool that has been developed under the framework of UN RED program and FAO to support countries in Latin America in the assessment of the access to mechanisms under Article 6 of the Paris Agreement. Next, please. The presentation is organized with 7 bullets. First, we will be reviewing the general aspects of Article 6 and the juridical requirements for its compliance. Then we will speak about some guiding questions for the analysis and the methodology used for the design of the tool as such. Moreover, we will be presenting the content of the tool and we will analyze the scope of Article 6, focusing on aspects related to authorization and transfer of ITMOs. We will also speak about the letter of authorization and its relationship with a national regulatory framework. And finally, we will speak about conclusions and reflections, centering discussion on how countries have made progress in this topic. Next, please. As we know, the Paris Agreement is an international agreement that is legally binding, adopted in 2015, that seeks to limit global warming. Its architecture, as we can see here, is organized in different blocks that are interconnected, related to mitigation and adaptation to climate change, that are work with targets with at the global level, national efforts, means of implementation, transparency, and ultimately, the conclusion of all this, at the conclusion of all this effort, we looking to have a worked balance on the effort, collective efforts to reach the objectives under the Paris Agreement. Today we will focus on the second block, on Article 6 in particular, which is a mechanism that allows countries and the parties to collaborate voluntarily under market and non-market trends to participate with their NDCs, reduce costs, and promote a greater sustainable development. Next, please. We well know, Article 6 is divided in 3 mechanisms. As we said, 2 are market-based and 1 is non-market. In virtue of Article 6.2 on cooperative focus, countries can share ITMOs bilaterally. In particular, Article 6.2 allows a host country to sell units of reduced emissions to a buying country in exchange of capabilities and access to technologies that are not available through their own resources. The buying country gets these units, or known as ITMOs, as Felipe mentioned, or results that are transferred internationally to cover any deficit in the compliance of their own climate objectives. It also allows the participation of public or private institutions that are authorized under this latter mechanisms, provided that the adjustments are made on the country of origin. This mechanism requires making the corresponding adjustment from the host country to ensure that every ton of reduced emissions are not counted twice to avoid double counting. The other mechanism is based on Article 6.4. It's based on a centralized mechanism supervised by a body appointed by the United Nations. It replaces the prior mechanism of clean development of the Kyoto Agreement and allows private or public institutions to commercialize these internationally to comply with their NDCs. And finally, we have Article 6.8, non-market. As we know result-based payments. This is a non-market scheme. In other words, these efforts in terms of reduced emission reductions do not involve commercial transactions as such. This last mechanism focuses on transfer of technology and coordination of public policies. All mechanisms, the three mechanisms, are subject to an official framework of transparency and must guarantee a high environmental integrity. To achieve this, we must follow some specific guidelines for transparency and authorization of credits. Next, please. Today, we will focus particularly in looking more closely about the national rules that countries must determine to ensure that they can report adequately and to protect the compliance of their own climate objectives assumed under the agreement and the convention, for which the countries must comply with a series of conditions that must also be reported before authorizing a transfer. Among them, they must be part of the Paris Agreement, prepare and communicate their own NDCs, and make sure to comply with participation responsibilities under Article 6, avoiding double counting of ITMOs through the application of corresponding adjustment referred in the guide of Article 6.2. And these are the elements we will review today under the tool institutional arrangement for the authorization process based on mitigation results. The way in which countries would make progress and comply with these conditions is what has guided the development of the tool and the analysis that we have carried out to identify gaps and also solutions and options for improvement in the institutional and regulatory framework. And now I'll give the floor to my colleague, Maria. Thank you, Francesca. Next, please. Well, for us to analyze these topics, we've identified that the authorization has different conditions or requirements to use the mitigation results that are used in the country. Francesca mentioned very clearly that we must apply the corresponding adjustments and verify that indeed we have the initial report from where these mitigation outcomes come from, comply with these reports at the level of the convention, and provide the corresponding information from the authorized party under the framework of cooperation, the mechanism that we are using. Also, we must have elements like the authorization of ITMOs and authorization from entities. We must also differentiate in this framework that one thing is authorization and something different is the approval of the activity that is eligible from the country to participate in these different cooperation mechanisms or market mechanism that Francesca has mentioned that are foreseen under Article 6. Next, please. Under the framework of UN RED program and following the needs that we have identified, we see the need to have an approach, and we reviewed very closely which are these aspects that should be reviewed under the demands of Article 6 of the Paris Agreement. And what you see here in these chart are the components that Article 6 requires First, have clarity on the application and also the requirement of Article 6, and also civil, human, economic rights transferred and ownerships, and aspects related to monitoring and follow-up, specifically related to counting, the baseline, national reports, and finally, amendments associated to administration process.
In this sense, we came up with some initial questions. If there's a legal framework for the MRV within the country, what is the legal framework linked to these topics? Is this legal framework, including the technical elements mentioned above, is there a record of initiatives for mitigation domestically? If it doesn't exist, are you going to use an international register? If the country is going to use third-party registers, or on the other hand, the country is going to design its own national platform, what will be the requirements for that design? Another question is, where would the mitigation information be recorded? Will you use an international register, third-party platforms or registers, or will you design your domestic platform? How will the information be standardized in the case different platforms and registers are used? The other question is whether other mechanisms that are available in the market are used. How will you prevent double accounting and the registration? And how are you going to make sure that the information is not used twice when we're doing ITMOs? Are you going to keep track of the quality of the units? And how are you going to compare the baseline? What methodologies are you going to use? It's a number of technical items that need to be considered. There are different questions that the country needs to answer when they want to meet the requirements under Article 6. There are a number of concerns that need to be addressed. And the question that always arises is whether or not the measures taken actually fit into what is being requested. So we can provide that kind of support through different methodological resources. For example, this tool, which took into account all the requirements set out in Article 6. We identified the criteria related to scope, accounting, safeguards, governance, administrative proceedings, national reports, monitoring, and follow-up. By doing this, we move on to the next phase. In this phase, we have guiding questions. Those guiding questions are linked to each of the requirements. We identify sources of information. Those sources of information may be available domestically. And here we tell them where they can look for the answer, whether it's a regulation, a policy, and so on. Once we have that, we come up with guiding questions for each of the criteria. Then we define the fields. There is a system whereby we ask the question, there's a field for the answer. There is also a field for analyzing the criteria, and then there is space for general comments. All of this is translated into a matrix. And in 2024, 2025, we used this matrix in Bolivia and Chile. This was a pilot program. Based on those results, we were able to systematize and adapt the tool. We adjusted it, and what we are sharing with you is the final design of this methodological tool that has been tested. So as you can see here, we have the final layout of the tool. Each country can use it and can determine to what extent their legal framework is advanced, the capacity of their country to fulfill the requirements of Article 6, what gaps you have at a regulatory level, what can be done to come up with a better roadmap to meet the requirements. In the left, column, you will find the criteria. Column number 2 is the questions that we suggested. The other columns are available for you to fill out in the future, taking into account your own reality, your legal framework, and policies. As for the scope of application, the country must ask itself is if it's going to use the mechanism set out in Article 6, whether it's going to appeal to one or the three of them. What sectors can tap into those mechanisms? And then we wondered if the forestry sector has any potential to access to the mechanism set out in Article 6. Is it available for the three mechanisms or only the one in paragraph 2? Who can decide what reduction of emissions can be used under the scope of the Paris Agreement? We also asked what national authorities you have for the following duties: for accounting of reduced activities, what activities are carried out nationally, and to implement the human rights activities. As for governance questions, we asked what entities would benefit from the transactions carried out under Article 6. Will it be the same entity that is already benefiting from their REDD activities? Is it going to be a public agency? If that is the case, how will the focal point in red connect to the other entities that may have a role assigned under the process that has been established? As for economic, social, and civil rights, we asked the following. Does the country have an EIA in place? If the answer is yes, how can this system be linked to the requirements set out in Article 6? Is it necessary to supplement it in any way? Is it enough? Are there any loopholes? What is the entity in charge of following up on safeguards on the environment and social matters? Is there a safeguard mechanism? Who establishes it? Who manages it? Are there any reporting mechanisms on safeguards? How would that be applied? How would we apply the free, prior, and consent for the prior consultation mechanism? So all of these are questions that are set out. As for transferring of titles, the questions are the following. Is there a government entity authorized to manage the emission reduction? Who is the holder of carbon domestically? Does the ownership of carbon have any direct relationship with the kind of titles on which you hold the land? In our countries, we have public, private, community, indigenous territories. There are also ethnic territories. It's necessary to have this set out and spelled out. Do we need to have clear regulations? Do you think that we don't need to trickle into those little details? Yes or no? You need to answer these questions. Who is entitled to claim property over carbon when it is stored in the forest? Who is the holder of the carbon rights? Who is the holder of the community held carbon? Uh, and how about credited agencies? Is there any clarity on the rights beneficiaries have? What kind of benefits will they enjoy as a result of the transactions linked to reduced emissions? Moving on to accounting, the following questions are asked. Does the country have a register system for reduced emissions? Who controls the register? Who has liability on managing it? Do you have a procedure in place to record reduced emissions? Is this done by the title holder? As for the baseline, is there a process to ensure that these units are real, additional, verifiable? What entity is empowered to ensure that these entities are true, identifiable, and verifiable? Does the national system have a certification process to certify that these units are real, additional, and verifiable. Talking about the additional component, what entity is in charge of determining the activity or measure that can be considered additional? Is there any procedure to establish it? As for administrative items, what is the national approval process for mitigation measures for projects? If this is additional, how would we authorize the ITMOs transfer? As we were mentioning at the beginning of the presentation, these are two different components. However, they supplement each other in order to establish the ITMOs properly. Moving on, we can determine the scope of the requirements of those transfers. As we all know, the Paris Agreement establishes two mechanisms that are market-based, as Francesca was mentioning. This helps countries in increasing their NDCs while safekeeping their environment. The parties to the agreement must establish a set of domestic regulations to ensure that it timely fulfills its NDCs. In this sense, countries must meet a number of requirements. They need to be reported before the transfer is authorized. As Francesca mentioned, we need to consider the following items. You must be a party to the Paris Agreement to prepare and communicate the NDC, to establish the institutional framework for authorization purposes, to establish the institutional arrangement for MRV of mitigation results, to provide inventories for the most recent year, and show how this contributes to the NDC. What do we understand by authorizing transfer of ITMOs? This is the official document. Through this document, the state authorizes the ITMOs to be used by other countries or international buyer in accordance with Article 6.2 of the agreement. So here there are two phases. First, the approval of the project. The state or the host country agrees to include a project in the mechanism. The second one is the authorization of the transfer of ITMOs. Here, the state authorizes the reduction to be transferred internationally as an internationally transferred mitigation outcome. For this purpose, it issues a letter and it undertakes to make the appropriate accounting adjustment. That authorization letter recognizes that the reduction of emissions were carried out within its territory. Then it authorizes for these outcomes to be transferred internationally. Third, it must express that it accepts to make the appropriate adjustment in its accounting element to avoid double accounting. And that letter should also expressly state that transfer is consistent with domestic policies and NDC, and also should establish that the transaction falls within the legal and institutional framework in place at the domestic level. So what does the authorization letter include? First, it must identify the program or project that is issuing the ITMO. Then it must point out the name of the project developer or the program. It must determine the authorized amount of reduction that is authorized, the country that is benefiting from it, the express statement of the authorization for the international transfer, the commitment of state to make the appropriate adjustment, the confirmation that this transfer supports sustainable development, and that it meets the requirements set out in Article 6. They must be signed by the competent authority, and it must be linked to all the requirements of Article 6 of the Paris Agreement. Within this context, the role of the national regulation is divided into two components. First, all countries must set out the competent authority. This is the one that will authorize participation in the programs and projects set out in Article 6. Secondly, we need to define the entity who is responsible for developing the technical and legal items to issue that authorization letter. And then we need to point at what authority is responsible for issuing the letter. Once that has been done, we need to also determine who is responsible for doing the counting adjustment. Set out the procedure to make these adjustments. This is all under the scope of Article 6 and transparency procedures in place. I would like to share some final thoughts and conclusions based on the application of this tool in the pilot program. The procedures for the authorization of projects and the authorization letter are essential requirements to implement the Paris Agreement. It can be done so transparently and thinking about the environment. There is a requirement to state the competencies domestically so that there is no overlapping between the different levels of government or agencies within a country. It is aimed at strengthening the governance domestically vis-a-vis international markets of carbon. Then the procedures must give investors guarantees, reduce legal risks, and move towards mitigation initiatives. Countries leading the implementation of Article 6 in Latin America have developed specific regulatory instruments instead of giving instruments through specific mechanism. Why? Because this provides greater certainty domestically. That way you have clear procedures and it creates a greater sense of security for investors. Regional experience shows that the success in implementing Article 6 greatly depends on consolidating the legal and institutional framework more than having investors and ensuring procedures to transfer the accounting mechanisms and reducing the accounting figures. Chile has a good example. It passed a law. It establishes the procedures for ITMOs. It also spells out what the authorization letter must contain. It has set out a committee, and an additional resolution was passed in 2026. Here, they define the different kinds of activities that can be authorized and what activities cannot be authorized. And that way, we have a list of what kind of activities can be authorized. The Ministry of the Environment of Chile is the entity keeping the record and approving the projects, the eligible projects under Article 6. It is also the body responsible for issuing the letter. These legal instruments provide certainty and tell people what kind of steps they need to take in order to fulfill the requirements set out in Article 6. Colombia, through the Ministry of the Environment and Sustainable Development, is putting in place a project to ensure ITMOs and to implement the Paris Agreement. This is in addition to a law that was passed in 2021. They also have a record. The bill is aiming at establishing the competent authority, the procedure to follow, and how the accounting adjustments will be made. This bill was subject to public consultation as required by the domestic law. Then the Ministry of the Environment will approve it. There are strict social and environmental standards that need to be fulfilled. In the case of Colombia, it is state driven, and the purpose is to ensure social and environmental safeguards. It has established additional requirements in addition to those that have traditionally been sent out. They also focus on human rights and social rights. The methodological tool that we have implemented in the UN RED project is a good tool. It enables us to have a standard way of carrying out the analysis. It can help you in determining what kind of measures need to be implemented to upgrade your legal framework. This is a guide and it can help you in developing the step by step procedure that needs to be followed to ensure that the mechanisms of Article 6 can be effectively implemented in each of your countries. Thank you very much. Thank you very much, Gloria and Francesca, for this presentation. A key idea is that implementing 6.2 does not begin with the actual transfer, but it actually has a prior requirement. It requires the state to have some measures in place, like the authorities, the procedures, the requirements. This is are important challenges. The tool you have shared with us, Gloria, turns this challenge into something concrete that establishes steps to be implemented with a safeguard. Yes, to continue, we would like to become familiar with a toolkit to support the development of regulatory frameworks relating to carbon market schemes. We have with us Fabiano de Andrade Correo. He's a senior advisor to the Environmental and International Law of the World Bank. He's an expert in international law and climate change. And this is why he has been invited to share with us his thoughts today. Fabiano, you're welcome and you have the floor. Thank you, Felipe. Good morning, ladies and gentlemen. I'm very happy to be here. I will share with you some of my insights. I'm also happy to see some colleagues from Chesca, Gloria, with whom we have worked before. It is always a great pleasure to support the processes in Latin America. I am originally from Brazil. I work in the World Bank in the Washington, D.C. office. Linked to environment and carbon related topics here. If you allow me, I would like to share my presentation. Felipe, can you tell me if you can see my presentation? Yes, we can. Yes, we can see it. Great. As Felipe stated, the reason why I'm participating in this panel today is to show you a toolkit that we have developed in the Environmental and International Law Department at the World Bank. It is a toolkit on development of regulatory frameworks relating to carbon market schemes. Let me share with you the background. Why did the World Bank decide to develop this toolkit? This toolkit, by the way, in my view, greatly complements the tool that Gloria and Francesca have described earlier today. Why? Because the approach of this toolkit is not so much as to explain the key items, but rather to focus on the implementation, in other words, the how countries can implement it. The legal office at the World Bank provides support at regulatory levels for those countries that are undergoing legal upgrade on environmental and carbon market schemes. We also provide support to carbon funds held by the World Bank as a trustee, such as the Forest Carbon Fund, for which is the Forest Carbon Facility. I work hand in hand with this fund. In these two avenues, we have noticed that there are important challenges, and in many cases, the countries face bottlenecks that prevent them from participating in carbon projects. The lack of appropriate regulations, for instance, that enable their participation is a great problem. As a result, the World Bank came up with this tool to help countries and to guide countries on how this can be achieved. The purpose, as I said, was to provide practical guidance and to support countries in developing and implementing a legal and institutional framework to tap into the carbon markets. We always emphasize in integrity for the bank. This is a key characteristic. It's not just a matter of promoting and participating in a carbon market, but it needs to be long term, ample, and provide financial support to countries. But this must be done while respecting environmental and social rights of everyone. The scope of the toolkit is carbon credit, and it does not cover emission markets. It does consider voluntary markets as well as markets under the Paris Agreement. Some of the slides are in English, so I'm going to try to explain in Spanish what they say. The toolkit is not available in Spanish yet. It is planned, though. We have divided the scope of the toolkit into 6 major areas. The idea is to start by taking stock of the instruments available to identify the most appropriate legal instruments. This does not take into account directly the legal framework or public policies of each countries, but by pondering on these questions, we can identify the most suitable instrument, we can identify the institutional framework. The following 5 phases talk about the creation of the credit itself, the eligible activities, the standards, the methodologies that the country needs to implement with and that is suitable to its national case. These are aspects associated to infrastructure, monitoring, and registration. And then an important aspect that Gloria mentioned is the definition of legal rights. Who is the carbon related to? We also provide a legal definition of what the carbon credit means domestically. This is also important for many countries as it has not been done. We have focused a lot on defining the asset itself. There's a chapter on the topics we're discussing today, the transactions per se, so regulating transactions, authorization procedures for voluntary markets, as well as the mechanism set out under Article 6. And finally, aspects linked to the enforcement of the legal standards and dispute settlement. This is a snapshot of the key aspects of the toolkit. And what I will try to do very briefly, because we're running a little bit behind, is a look at what
So
chapters.
we will be looking into chapters 1 and 5 of the toolkit, more related to the topics that we are discussing today. Um, Still, as an introduction, the toolkit is pretty long. It has more or less 150 pages. Thus, the idea was for this to be a very complete tool. And we wanted it to be very detail oriented. But we can use it on a modular approach, or users can see the chapters or consider the chapters as self-contained. It is not necessary to use all the toolkit at once. And at the same time, we've made an effort to make it very practical and user-friendly. So for some of the topics, the toolkit offers a table with advantages and disadvantages to follow one approach or another, and presents examples on how the country could develop legislation on the matter. Majority times we have concrete examples on how countries have followed legislation on the matter. So to provide a few examples, regarding the institutional framework, that implementation is very important, as well as supervision of carbon market, and this must be determined by juridical frameworks to provide the necessary power to authorities and also juridical security. Many countries already have instruments that support these competences, but it's important for countries to undergo an assessment to define if existing competences are enough, or if new legislation would need to be approved, or to create new institutions, or also if existing institutions could be reformed. Hence, the toolkit contains a step-by-step to guide countries in this process. And it suggests more specifically that the supervising framework has three types of complementary institution: a high-level decision body that determines general guidance of policies in accordance to legal mandate to approve decisions, and ensures the alignment with national climate objectives. We also have an executive or more administrative entity to develop detailed norms, procedures, and guidelines. For instance, to make decisions on authorization and maintenance of the registry, and also a consulting committee to provide a knowledge on technical aspects, and also specific functions on ITMOs with follow-up systems, for instance, transaction registries, mitigation activities, and mitigation results, and ITMO. Also formulation and application of conditions. But for example, the authorization, that is a fundamental element. The toolkit presents the example of Ghana, that has approved a framework on international carbon markets and non-market approaches, under which the Ministry of Environment works as a primary entity responsible for the implementation of the participation of the country, set out in Article 6.2. Right, that provides the policy guidelines and also manages authorization. Another functions are distributed among other agencies, including, for instance, an interministerial committee of carbon markets. Therefore, as I've explained, the toolkit always seeks to bring these type of examples to facilitate the exchange of experiences and also to provide examples on how countries could prepare their legislation on the subject. Matters relating to transactions of Article 6 procedures for authorization of ITMOs, it is also very important for this to be foreseen in the legislation. The toolkit presents two main procedures. First option, where the legislation foresees a process in two stages, having a first stage of initial approval, and further, the country to issue authorization letters through the implementation process, or rather that this letter is provided by the beginning of the process of mitigation. As I have explained, and as you can see on the right-hand side of the slide, on the same matter, we explain the advantages and disadvantages of each approach. Another very important element. It is important and interesting for the legislation to establish the format I will use. The country can always develop its own model of letter of authorization or use what the Secretary of the Convention has used. On this same matter, the toolkit presents the example of Uganda, another African country that presents that has rules on the topic. This is divided in three stages for the authorization of ITMOs. To later go on the authorization and the issuance of authorization letter. So as I've explained without going into much detail, I'm sorry, but the signal is coming on and off from this speaker. I'll do my best to continue interpreting. Here we have a QR code that you can use to download the full toolkit. And with this, I give back the floor to Felipe. Thank you very much. Thank you so much, Fabiano, for your excellent presentation. The toolkit reinforces the fact that there's not a unique juridical architecture in carbon markets and that each country must adapt the design to their context to determine the role and criteria for authorization. I understand that the fact that the mechanism to be modular allows to have more juridical insurance. So if you have any links that you can share with us, they're more than welcome. With this presentation, we close the first block of our session, and I think that toolkit complements very well with the tool that Francesca and Gloria presented. We're a little behind time, but please remain connected. We might have a 15 or 20-minute delay. And I'll also like to inform you that the recordings will be uploaded to the link to the event, and that we are also checking your questions and comments that we will be tackling later in our session. Next, we will have a panel of regional experiences. This panel will be moderated by Francesca Pellicani, and I will now give her the floor to continue guiding us. Over to you, Francesca. Thank you very much, Felipe. Dear participants, please allow me to change languages now because two out of our three panelists are English speakers. Thus, the first part of this discussion and presentation of experiences will be held in English. And after that, we will come back to Spanish, the presentation of Honduras.
So, dear colleagues, participants, let me introduce you three distinguished experts representing Singapore, Guyana, and Honduras, who will share practical experience and insights from their respective countries with regards to the implementation of Article 6.2. So our first panelist, and I thank you very much, Lydia, for staying with us because it's very late now in Singapore, is Miss Lydia Tang. Miss Lydia Tang is the Assistant Director in the Green Economy and Sustainability Division of the International Trade Division at the Singapore's Ministry of Trade and Industry. Ms. Tang leads Singapore's bilateral engagement with countries, particularly in the region of Latin America and the Caribbean, in order to strengthen cooperation on Article 6 of the Paris Agreement and to advance carbon market initiatives. She has also been directly involved in the UNFCCC negotiations under the Article 6, bringing valuable perspectives from both the policy and international cooperation dimensions. Lydia, thank you indeed for being with us today, despite the time difference. This is really mostly appreciated. We know that Ms. Vicky Young, your Deputy Director, is also with us and may intervene in the discussion. Let me then start by addressing you two very questions. I know you have a PowerPoint presentation, so I will ask my colleague Gaia to start sharing also your presentation. So based on Singapore's experience, which we know is actively engaged as a buyer and partner country under Article 6.2, could you please tell us what you would identify as the most critical capacity or institutional aspects that countries should prioritize when preparing to engage on the Article 6 cooperation schemes? And can you also please share with us the Singapore's strategic approach to engage under Article 6.2? Thank you very much. The floor is yours.
All right. Hi, everyone. I'm Lydia, and thank you so much, Francesca, for the questions. So, thankfully, the questions can be answered in the slides. So maybe, perhaps without further ado, let me have a short presentation, for about Singapore's experiences in the Article 6, Singapore's approach, some opportunities that we see, as well as some of the challenges that I think would actually answer the question on capacity building for countries. Next slide, please, Gaia. Thank you. So broadly, Singapore's approach to Article 6.2 collaboration typically follows a three-step process. This systemic approach ensures that both Singapore and our partner countries can collaborate effectively while maintaining high environmental standards. We usually begin with a non-legally binding memorandum of understanding or letter of intent. You can think of it as a first handshake. What it really does is that it signals both countries' interests and commitment to exploring Article 6 cooperation. This initial step allows us to establish mutual understanding as well as align our expectations on how we want to move forward on the Article 6 approach. Secondly, this is where we usually formalize the commitment through a legally binding implementation agreement. This agreement is crucial as it establishes the detailed framework for our cooperation. This implementation agreement actually creates a clear framework for two elements: how mitigation activities are implemented and how carbon credits are transferred internationally. Every project must meet stringent environmental integrity principles and criteria that both countries have agreed upon. This ensures that the highest standards are maintained throughout the process. Secondly, the implementation agreement also includes provision for the authorizations of credits by the seller country, complete with what we like to call the corresponding adjustments. So this is a vital feature as it enables these credits to be counted towards the NDC while also preventing the double counting issue. As of this year, Singapore has actually signed 11 implementation agreements with partner countries, three of which are in the Latin American region, including Peru, Chile, and Paraguay. We do also have around 20 or so memorandum of understandings that we have with countries across the globe. So that is step two. For step three, that is the final step that occurs after the implementation agreement is operational. So typically what happens is that after the signing, both countries will actually work towards an agreed upon set of forms for project developers and interested stakeholders to submit their projects for review and approval. This is also when the actual carbon credit transfers and corresponding adjustments will take place. So broadly, Singapore's approach, we actually leverage existing market mechanisms through our eligibility list of methodologies that align with our environmental integrity criteria. What this means is that we do leverage on existing carbon crediting programs such as Vera, Gold Standard, Artrees, and so on and so forth, as we believe that we can actually benefit from established capabilities in ensuring that carbon credits are robustly validated, verified, issued, and retired. This approach actually also enables a faster time to market and streamlined processes for market participants. We also see it as quite beneficial in promoting transparency and comparability across projects. So secondly, which is the next slide, please, Gaia, is that we do see opportunities in Article 6 carbon credits cooperation. So I think this was shared in the previous session as well, but what we do see is that Article 6 carbon credits actually unlocks much needed capital for mitigation projects which otherwise would not have been implemented. So when Singapore-based companies or like-minded buyer countries do purchase these credits, the revenue flows directly to finance mitigation projects in our partner countries. This actually unlocks additional emission reduction projects that would otherwise be unbankable, creating a win-win situation. For our partner countries, these projects also bring multiple benefits as they attract investments, create local jobs, and facilitate technology collaboration. Beyond the financial aspects, these projects also deliver tangible, sustainable development benefits for local communities. This can range from improved access to clean water to enhanced energy security. So, where we see ourselves is that we are not just a credit purchaser, but also depending on our partner countries' needs, we can also contribute through financing, capacity building, as well as technology transfer. So, next slide, please. So this is where I will talk a little bit more about the challenges as well as where we see capacity that is needed before partner countries can implement Article 6 cooperation. So this is actually quite a huge range of things that we do see, including an Article 6 strategy that is nationwide, a robust regulatory and institutional framework for carbon markets, an authorization process for corresponding adjustments, relevant infrastructure, including registries. I think there was an earlier presentation as well, asking a question about whether you can think of whether you want to set up your own domestic registry or will you be relying on an international registry. So we are also looking at a monitoring and verification process, meeting reporting requirements such as the initial annual reporting and the biannual transparency reporting as well. That happens, I think, once every 2 years. Also figuring out sectors and projects that could be approved, methodology assessments and development for eligible projects, as well as project development and initiation. So we do see that all of these factors are quite key if you want to have a very holistic implementation of Article 6 corporation. So also next slide, please. What we do see that is quite useful when you are thinking of all these little pieces to implement Article 6 is to have an interministerial task force that could actually support the coordination and policy alignment during this implementation phase. So from our experience, we find it quite useful for the committee to have a task force lead, typically from the designated national authority, who is usually from the environmental ministry. Then this task force lead would then actually coordinate with relevant ministries, including the legal team, foreign affairs, finance, commerce, trade and industry, as well as relevant line agencies that will be overseeing sectors with eligible projects, such as forestry and energy. So basically, this is where we do see is quite critical for I think countries to think of before you embark on your Article 6 collaboration. I do have some questions which might potentially be a little bit repetitive to the previous presentation, but we do have some questions that you may perhaps you'd like to think of. Like firstly, where do you see the current progress of your country's Article 6 framework development, which we do see as the most important building block when you're embarking on this journey? Do you have a vision of potential sectors that could be considered for Article 6 collaboration? A very important question of whether you are considering to leverage existing carbon crediting methodologies, such as from Verago Standard, or are you intending to develop your own methodologies when you're looking at Article 6 projects? Lastly, if you do have any plans for developing a domestic registry, or you would like to have, to tap on the international registry, and in addition to that, if you are thinking of having any functionalities to be interlinked, such as with other registries from Vera and Go Standard. Yeah. Thank you for your attention and happy to receive any further questions on this. I'll pass the time back to Francesca. Thank you.
Thank you. Thank you very much indeed, Lydia, for this insightful presentation. Actually, a few key messages indeed stand out. First, a successful Article 6 cooperation requires a clear and stepwise approach, moving from initial political engagement to legally binding agreements and finally project implementation. Second, carbon markets can play an important role in mobilizing finance, technology, and capacity building in order to support further commitments in terms of mitigation activities. And third, that countries need indeed strong institutional and coordination mechanisms, technical and regulatory systems, including robust MRV frameworks to participate effectively. So thank you really very much for this insightful presentation. I just may have a very quick further question for Singapore. I know it's very late for you, so then you will be able maybe to greet us if needed. From Singapore's perspective, what would you consider makes the forestry and land use sectors particularly attractive or maybe challenging for Article 6.2 cooperation?
Yeah, so I think I'm happy to take that question. So generally for Singapore, we are quite project agnostic. So we do accept forestry projects, but of course, I think there are certain considerations for forestry projects, including the potential, I would say, overestimation of credits that could be generated. So I think what we see as something that's quite important is to make sure that forestry projects are guided jurisdictionally to ensure that there is no I would say over issuance of credits, as well as ensuring that there is no double counting. What we do also see as a key challenge for forestry projects could also potentially be issues relating to land rights. So this is I would say a topic that would need to be navigated well when you're embarking on forestry projects. Yeah.
Right.
But I would say that nonetheless, we do see a lot of potential in forestry projects. So yeah, we're happy to consider this. Thank you so much.
Thank you. Thank you very much, Lydia. Thank you very much for your time, for staying with us. And we do hope that we will be able to continue any form of communication and collaboration after the webinar. Thank you very, very much. So let me now pass to our second panelist. Our second panelist is Madame Maria Sukdeo from Guyana. Ms. Sukdeo is a GIS and remote sensing specialist with academic training in both forestry and geospatial science. Her work focuses on forest monitoring, land use mapping, spatial data analysis, and environmental management. She has applied geospatial technologies to support sustainable forest management and evidence-based decision-making in Guyana. Dear Maria, as we do know, Guyana is one of the world's leading examples of operationalizing REDD+ carbon credits at jurisdictional scale and linking them to Article 6 implementation. In that regards, can you please describe the phased approach adopted by Guyana with regards to accessing carbon markets and Article 6? And as we dive into the institutional framework, can you also please tell us what have been the main challenges in complying with the various requirements set under Article 6.2? Thank you very much. The floor is yours, dear Maria. Thank you. I know you also have a presentation, so we will share it for you. Thank you.
Hello? Are you hearing me? Okay. Hi, good morning. So I am Maria. I work at the Guyana Forestry Commission. The next slide, please. So I'll answer most of my questions in the presentation as well. I think it has on transition, so you would need to press enter. Yeah. So our carbon market journey could be divided into 3 phases. In the first phase is where Guyana entered the partnership with Norway. It's where they agreed to provide payments for verified reduction of deforestation. And during this first phase, Guyana invested heavily in developing a robust MRVS system, forest monitoring capacity, our safeguards, national forest inventories, and our institutional governance. So the main objective during this phase was not carbon trading, but demonstrating that forests could generate value through verified climate performance. In the second phase was where we moved to a more market-based REDD+. So as international markets matured, Guyana shifted towards market mechanisms, and this involved us getting certification on the R3 standards, our jurisdictional REDD+ accounting, independent third-party verification, and preparing credits for voluntary and compliance market. In the third phase, looking ahead, Guyana intends to align all of our future transactions with evolving Article 6 guidance and future UNFCCC decisions. Next, please. So a clear value proposition, and I will explain why Guyana's program is internationally recognized, and it's due to a number of factors. The first one being our jurisdictional scale. So Guyana measures emission across the entire country rather than having individual projects. And this reduces leakage and provides confidence that emission reductions are real. We also have direct linkages to our NDCs. There is also routine UNFCCC reporting, and this program is built on our MRVS system, our Cancun safeguards, our biennial transparency reports, and our national forest monitoring system. And Guyana has committed to maintaining these systems for at least 20 years, giving buyers confidence that long-term monitoring will continue. We then have our independent verification, where every emissions reduction undergoes a third-party verification, a technical assessment, quality assurance, and a buffer pool allocation to manage reversal risk. And this greatly increases credibility in the international carbon markets. Next, please. So you would have seen this slide just now, but Guyana is moving into compliance markets. And what this does is allow companies and airlines that are legally required to offset emissions to purchase high integrity credits. This transition significantly increases demand, credibility, and potential revenue. So, because of the strong MRVS system and our certification developed in the earlier phases, it now supports participation in these regulated markets. So, our program demonstrates that a country can transition from bilateral agreements to internationally recognized compliance mechanisms. Next, please. Ghana follows a structured process before carbon credits can be issued internationally. So the process begins with the submission of Guyana's Article 6 initial report. And this report communicates to the UNFCCC that Guyana's participation in Article 6, how the corresponding adjustments will be applied, the accounting methods that are going to be used, and the national institutional arrangement. We then have the development of the national framework. So we established several national requirements before authorizing any credits, and these includes institutional arrangement, legal authority, authorization procedures, and governance mechanisms. So this process ensures that carbon credits are managed through an official government process. The host country letters of assurance and authorization. So before any credits can be transferred internationally, the government issues official letters that confirms that Guyana authorizes the transfer, that the credits are eligible, that the corresponding adjustments will be applied, and that the transfer complies with Article 6 requirements. So these letters provide confidence to the buyers that the credits have government approval. We then have the program registration and validation. So the Red Plus program must first be registered under the R3 standard, and independent experts then validate the program design, the methodologies used, the safeguards, and the monitoring procedures. And this part, the validation confirms that the program meets internationally acceptable standards before any credits are generated. We have the monitoring aspect, and Guyana continuously monitors its forests through our MRVS system, and this provides annual forest cover assessments, degradation monitoring, land use change detection, and emission calculations. We then have our independent verification. Monitoring reports are then independently verified by accredited third-party auditors, and these auditors confirm that the emissions are real, the calculations are accurate, the methodologies were correctly applied, and the safeguards have been followed. In terms of credit issuance, once the verification process is completed, R3 issues verified carbon credit. For Guyana, carbon credits currently cover our vintages year, which is 2021 to 2023, with approximately 7 to 9 million credits issued annually. Our credits are now CORSIA eligible for the period 2024 to 2026. So these credits are now being sold in the international carbon markets. Next, please. So the program has already generated significant environmental and social benefits, and we've managed to maintain our annual deforestation rate of below 0.1%. So revenue generated from the carbon credit program supports a lot of projects in sustainable forest management, in protected areas expansion, biodiversity conservation, And one of the strongest aspects of Guyana's program is our benefit sharing mechanism. So since 2023, approximately 22.5 million US has been distributed to approximately 242 indigenous villages. And these payments represent about 20% of the total carbon revenues. And the communities themselves decide on how the funds will be invested in the community. Looking forward, Guyana expects to expand participation in CORSIA compliance market. We want to continue implementing our low carbon development strategy 2030, strengthen Article 6 cooperation, and create a long-term sustainable financing for forests. So just to answer some of the questions, some of the main challenges we had in respect to the authorization process would have been establishing our domestic institutional arrangements for Article 6.2, aligning the various aspects of reporting across all the sectors with the NDC and the LCDS 2030, and being able to adapt to evolving international guidance and building technical capacity for ITMO tracking and data management.
Beautiful picture, Maria.
Oh,
And
thanks.
yeah, amazing. And thank you very, very much for your presentation. As we can see, Guyana's experience illustrates how a country can progress from RED Plus RBPs to active participation in international carbon markets. You highlighted the importance of long-term investments in forest monitoring, transparency, safeguards, and governance, with a strong need to develop a benefit sharing scheme and address the needs of local communities. It also shows that Article 6 implementation is not just about carbon accounting, but about generating tangible benefits, as you told us, by maintaining extremely low deforestation rates to support indigenous communities and financing national low carbon development. So thank you very, very much for your fruitful experience. And we now have to run to our third and last panelist. I will now switch to Spanish. So for the English speakers, you will allow me to switch to Spanish.
Now we will ask a stretch to synthesize, knowing that you will support us with time management, but without missing sharing the valuable experience from Honduras. Please allow me to introduce our panelists from Honduras. Mr. Manuel Enrique Erazo Godoy is an carbon fine head of Center of Forest Information and Heritage, Institute of Forest Conservation. He currently is the director of the for Forest Information Heritage in Honduras. In this position, he supervises the national follow-up of forestry follow-up and the elaboration of official maps and statistical reports that support international commitments that Honduras has, including the Red Plus program. Dear Manuel, thank you very much for joining us from Honduras. We also have some guiding questions for you, and we also know that you have a presentation to share. So we will ask Gaia to start projecting your presentation. The guiding questions refer to the reference of the juridical framework of Honduras. In particular, if you could please inform us about what are the enabling conditions in Honduras relating to transfer under the framework of Article 6.2. And also how you can favor transparency and climate integrity. Thank you very much, Manuel. Over to you. Thank you, Francesca. Thank you all very much for this invitation to participate in this webinar. Good morning. As Francesca said, my name is Manuel Erazo, and I work in the Forest Information Heritage Center of Honduras. To provide some context about the climate efforts that we carry out in Honduras, I'd like to tell you that recently we have presented an update of our NDC where we've included the LULUCF sector. And we are undergoing a process of modernization of climate change that had been approved in 2013. This effort serves to include the consideration set out in the Paris Agreement so we can modernize the Climate Change Act. Our government has a very strong focus on the protection of the forestry sector, given the high vulnerability it presents. And we're also looking at ways through which in the international markets, forests can fund their own conservation. And at the same time, to ensure the well-being of the populations that inhabit it. Next, please. Please, next slide, Gaia. Well, although Honduras has made important advances on the efforts in monitoring, reporting, data generation, we've made important progress in these areas. And for us to go into practice under Article 6.2 and access to markets, we did need to reinforce our juridical basis in our country. And an important step forward was the approval of the Forestry Carbon for Climate Justice Act, approved through Decree 54, 2023. This was a very important basis that allowed us to focus our efforts and to be able to coordinate and clearly define what were going to be the interinstitutional instances and the responsibilities of each institution. This was the spirit behind this act, to establish strict norms to ensure the transparency of transactions, to work on the harnessing of natural resources, and to define a coherent legal pathway. Needing some other previous acts on climate change and forestry laws for us to have a legal coherence. This is why these laws were repealed. It's important to define governance, and this is why the Act creates the National Commission for Carbon Transactions. This is an interinstitutional body where the Secretary of Natural Resources leads the commission, and it also assumes the international representation. ICS has the technical secretariat, and we are in charge of the comprehensive management of forestry risks. and also of the reports and verification. As part of the National Commission, we also include the Finance Secretariat to ensure the soundness of the transaction and to ensure economic benefits for populations, projects, and all benefits we can obtain from these transactions so they reach the populations they're meant for.
The law also establishes the technical body. This is set up by experts, technical staff. They are in charge of addressing any concerns the committee may have. They will provide the technical support and they will analyze the activities that are proposed for this purpose. The law has set out a 7-step process. This is aimed at certifying the activities. It ranges from acceptance, correction of any issues that may be missing, like adding documents. All of these steps are performed by the technical body. They carry out a comprehensive assessment. It takes into account legal aspects, technical components, as well as on-site assessment. In this way, they confirm that the activities are verifiable, national, and that they meet the requirements for the ITMOs of good quality. Once the technical body has carried out its assessment, it is transferred to the committee. The committee is the one that will certify or not the project, and then it will issue the certification letter. Environmental integrity. Under this scope, we need to ensure that environmental integrity is fulfilled. This is what the law establishes. We have an initial report. We have the authorization letter, and a number of parameters have been set out, and they need to be met. For instance, the activities must be close to the NDCs. For instance, the letter, the authorization letter, states the 2% of voluntary reduction for the global mitigation, OMG. That way we do more conservative calculations that may be more appealing to cooperating parties. With this, we can be reassured that we're working under the business as usual scenario. This is integrated to the national system on safeguards. As for legal certainty, this is what we wish to show cooperating entities. In Honduras, our goal is to have zero or neutral activities so that they cannot be repealed. Anything that is already provided cannot be repealed. The committee provide certainty to the ITMOs. And as we were saying, we want them to be high quality ITMOs. For this purpose, we have a rigorous MRV. We keep track of the areas where recovery tasks are implemented or they are protected. We carry out a combination of monitoring tasks, both by satellite imaging as well as field checking. We also implement campaigns on forest protection. We have a policy of zero deforestation by 2030. This has helped in reducing deforested parts in critical areas of the country. Well, something that is worth highlighting and that this legal framework offers is climate justice. Under this concept, we address 3 pillars to clearly identify the title holder, whether it's an individual, local community, legal entity, the state, identify who will be the ultimate beneficiaries of the financial resources. Then we have a special fund. This is for protected natural areas, and then investment. This ensures that the sale of ITMOs can help us in achieving Honduras's NDCs. We have some lessons learned, and we can make some recommendations on that basis. Legal frameworks must establish binding aspects. Roles and responsibilities must clearly be spelled out. Must establish what government agencies are going to be connected to the implementation of Article 6 of the Paris Agreement. Traceability is another important factor. The registers of ITMOs must be strictly kept and ensure the appropriate accounting system and avoidance of double accounting. That's what I can say. Thank you very much, Manuel. This has been a very thorough presentation. We would like to compliment Honduras for every effort they have made in the last 20 years. When I first joined FAO 20 years ago, I had my first mission to Honduras. You have advanced a lot from an institutional perspective as well as from a legal perspective on these matters. So thank you very much for your time and cooperation. Having said that, I would like to give the floor to my colleague Roberta de Souza, who will give us some final remarks. She is an expert in FAO and UN RED. So we can conclude. Thank you very much. Good afternoon. Good afternoon to participants. This has been an inspiring meeting. We have seen the pioneers on forest climate action under the scope of Article 6.